before I begin, one of the things I would note is in Jerry talking about computers and cell phones, and in talking about Jones, which is a GPS case, one of the things that struck, I think, many people that look at these cases is how different the court looks at the searches of these items as opposed to contraband. And it's clear that the court's clerks, the court's spouses and friends all have items such as these. They have and work on computers, they have and hold cell phones, their automobiles and other things have GPS in them. And so these decisions are decisions which it seems clear the court recognizes impact not just those who might be guilty of something, but everybody, everyone that comes before them and others who will never come before them either as lawyers or as litigants. And their decisions seem to understand the breadth of the impact of their decisions, not just on those that might be guilty, but on everybody that really walks the earth. So I think that puts some of it in context and explains somewhat the decision in Jones. So Jones is a GPS case that arose a couple years ago, I think in 2012. It was also unanimous, but in 3 different opinions. And in Jones, the law enforcement placed an outside GPS device on a car. There was a warrant, but this was done outside the confines of the warrant, so ignore the warrant. And proceeded to trace through GPS the movements of the car for a period of over a month. Case comes up to the U.S. Supreme Court, and the decision is 5, 1 concurrence, and then a separate 4 member concurrence as well. The last concurrence to me is one of the most interesting groups of justices to come together. The last concurrence was written by Alito, joined by Breyer, Kagan, and Ginsburg. And the majority opinion was written by Scalia, and the 2 opinions, Scalia and Alito's concurrence, are interesting. The most far-reaching of them all was the separate concurrence by Sotomayor. So Scalia for the majority says this is a traditional search and seizure because there was a physical intrusion onto an item of property, that is placing the GPS device on the car. That's a very limited opinion when you think about it, because you don't need to do that really to do GPS tracing anymore with people having their phones and the like. But he analyzed it under the traditional view of property and said, this is an intrusion into property. There's no warrant. It just doesn't work. Justice Sotomayor said, yes, we look at property, but we also look at CAT's reasonable expectation of privacy, but we also should look at a third thing, which is traditionally we've said that which you've exposed, that is bank records which you've given to somebody, or health records, or your phone records, have no expectation of privacy because you're putting information out into a third party's hands. And we shouldn't be looking at that only. We should be looking at the greater question of privacy rights and expectation of privacy. And are you really waiving that in a world where all of your data, everything we own, we now are required to have our health records on computers for centralization. If you're participating in certain health plans, you're required to have, I must do my banking online to pay my state taxes in California. I cannot pay my state taxes without having online banking, and various other things where everything that we had thought were private, that is, that you want to control privately, it is impossible to control privately. So she actually suggests that what we need to do is look broader at how our world lines up with our expectation of waivers. The last concurrence, the Alito concurrence, was actually amusing in the way it took on Scalia and his view of Fourth Amendment interests. He looked at it from a CAT's point of view. That is, you have a reasonable expectation of privacy in your movements, even though somebody might be able to actually hover above you and watch every movement you made. People don't expect that, and there's a lot to be covered, and that CAT's would protect it. He thought that Scalia's position was pretty funny because all it meant, because he was going way back to the origination of the Constitution, the origination of the Fourth Amendment, was you would have a constable in the back seat of your car, and if you could do that, then that would be okay. But those are the three different views that came out there, but the court came out unanimously to say that this is an intrusion and it is covered by the Fourth Amendment, and you just can't go ahead and do that, because even though you might be able to see someone on the street when they're driving, putting a tracking device, a GPS device, is a higher degree of intrusion than we are used to, and there are interests involved. Scalia, property interests; Alito, interest in privacy. And Sotomayor going both ways. How does this play in other things? Well, the court has been dealing with these devices one at a time, so they deal with cell phones and they say, go get a warrant. But what Jerry alluded to is, what does that warrant do or mean? A cell phone is really no different than a computer. My iPhone contains more information than my computer could have contained 3 years ago, and connects to more things and shows people more of what I do. And every day it gets more and more intrusive. It has every publication that I've read, every book I've ordered, every person I've talked to, how long I spend, frankly, in a ladies' room, you can track with my cell phone. If somebody was there with me and we were chatting, personally, you could probably match up the two cell phones and see that we were there. So what do you do now that you've gotten a warrant? That's the question that's outstanding. Get a warrant means what? Does it mean that you have a warrant for the computer and you can go in? Does it mean you always go get a warrant? So every search now, at the end of it, in my home state of California, every search warrant I see now from the state ends with, and seize all computers, cell phones, or other electronic data and search for evidence. What does that mean? Why do you get to search the computer? What is different about it? There are no guidelines yet from the Supreme Court. That will be the hardest decision. CDT, which comes out of California, started to do that by putting up a protocol, but backed off from that. That's the question, and that's where I think most of the motions are lying now, both in the actual execution of the search and in the expression of what you can search in the warrant itself.